This is not your average day in court. What you're about to see is a defendant who knows the law, at least thinks he does, going toe-to-toe with a judge, challenging everything from the charges against him to the very definition of custody. We've got multiple cases rolled into one, allegations of fleeing police, drunk driving, license suspensions, and even an escape charge. But here's the kicker, he claims some of these charges are facially invalid, because he wasn't in a jail at the time. Over the next few minutes, watch as legal arguments clash with courtroom authority, and tensions rise over what's fair, what's legal, and what's just plain bold. You're going to hear constitutional challenges, accusations of procedural delays, and even a civil lawsuit filed against the judge herself. And stick around, because the twists in this hearing say a lot about how the justice system handles determined defendants.
The definition of the statute itself, Your Honor. It compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid.
That were going to be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further, in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are account.
And there's our first big moment motion denied. In legal terms, that's the judge saying, you can argue this later, but right now, the case stays on track. This is important. Judges often refuse to dismiss charges during early hearings because the prosecution hasn't yet presented all evidence. The defense wants the case thrown out now, but without a full evidentiary review, that's a long shot. Still, this push tells us something. The defendant's strategy is to attack the legal foundation of each charge before trial even begins. The question is, will this aggressive approach win over the court or just irritate the bench?
And that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir, do
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then
Here, the defendant is zeroing in on one of the most fundamental principles in criminal law: proof beyond a reasonable doubt. He's challenging the prosecution to prove 3 separate elements of the charge: that his license was revoked or suspended, that he knew about it, and that he was driving on a public road. If the prosecution fails to prove even one of these, the entire count could collapse. This is a textbook example of attacking the weakest link in a case. But remember, these are still just words. The real test comes when evidence is introduced.
Interdepartmental to jail staff to serve on Mr. McGill, and I expect those to be in the interdepartmental mail tomorrow.
got it. Okay, so we're not ready. He hasn't gotten the
He
video.
has all video discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure yet.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him?
I expected you would have them early next week. So if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then
have them in well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you.
That's a significant move invoking the constitutional right to a speedy trial. Under the Sixth Amendment, this forces the court to move forward without unnecessary delay. Defendants often do this when they believe the prosecution isn't ready, hoping to catch them off guard. But here's the risk. A fast trial can also limit the defense's own preparation time, especially for someone representing themselves. So is this a tactical masterstroke or a gamble that could backfire?
90 days operating without security, which is a misdemeanor punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. There is, however, a third.
Now the stakes are becoming crystal clear. We're not talking about a single misdemeanor anymore. This is a stack of charges across 2 separate cases, including a third offense DUI that bumps it up to a felony. That's prison time, thousands, in fines and mandatory rehab programs if convicted. And let's not forget, felonies carry a lifetime shadow, affecting jobs, housing, and even basic civil rights. The courtroom atmosphere just got heavier.
The court deems necessary. Court could order you to pay the cost of the prosecution, plus the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the prosecutor.
Mr. Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these 2 cases now become public defender cases.
Thank you, Judge Torture, Officer, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set it I will set these for preliminary examination.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay.
And just like that, the self-representation experiment is over for now. Accepting a public defender means the defendant will have trained legal counsel, which can be a smart move given the complexity of the charges. But it also changes the courtroom dynamic. Judges tend to expect more procedural polish from lawyers, and the defense strategy may shift entirely. It's worth asking, was this a genuine need for help or a tactical pivot to strengthen his case?
Provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
In response from the people regarding his bond.
People would ask the bond be continued, and he also, I'm sure, failed to appear before Judge Slade's. So
yes.
That warrant would also hold up with respect to the other. I'll wait. If there are pleadings filed by the defender's office, our office will respond to that. And I guess my one remaining point was
this is the defense going for a personal recognizance bond, essentially release without paying bail. The pitch. These are mostly misdemeanors, and he's not a flight risk. But the prosecution has an ace up their sleeve, a prior failure to appear, and an escape from custody charge. Those facts are bail poison. No judge wants to be the one who lets someone out, only to see them disappear before trial. And in this case, the judge's mind seems all but made up.
Maybe. My understanding is that he is still held, regardless of what the bond would, in this case, he's being held without bond in Judge Slade's case.
that's my understanding.
That his bond has been denied. So
That's what I heard.
But I would,
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh, yeah, in that regard, Your Honor,
Many of those, do not interrupt me.
Well,
including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individual.
Here's where the courtroom drama crosses into rare territory. The defendant has filed a civil lawsuit against the very judge hearing his case. That's not just unusual, it's a high-risk move that can be seen as an attempt to force the judge to step aside. But here's the catch. Unless the lawsuit creates a real conflict of interest, the judge can stay. And in this case, she's making it clear she's not stepping down. It's a bold play by the defendant, but it may have just closed one more door in his defense strategy.
At this point, we continue to proceed with this case until I do otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Somebody be able to continue.
Appreciate it.
So, where do we leave things? 2 criminal cases, 1 defendant with a long list of charges ranging from misdemeanors to felonies, and a courtroom that's already seen motions denied, bonds refused, and even a civil suit thrown into the mix. The preliminary examination is now set for August 19th, where the prosecution will have to prove enough evidence to justify going to trial. For the defense, this is make or break. Either they chip away at the charges now, or they face the full weight of trial proceedings. If you found this case as intense and unpredictable as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.